Our last speaker today is Jovalin Dedaj. Jovi recently spent a semester in Washington, D.C. at Georgetown University, where he also interned in the voting section of the Civil Rights Division at the Department of Justice. Since his sophomore year, Jovi has spent his time researching and studying the topic of voting rights, specifically voter registration policies and identification laws. As a political science major in the Department Honors Program, Jovi is currently working towards completing an honors thesis. His thesis project will examine the recent tension between the courts and the Justice Department with respect to their competing interpretations of Section 5 of the Voting Rights Act and their conflicting views on voter ID laws. His talk is titled ID Please, How Voter ID Laws Threaten Your Right to Vote. Please join me in welcoming Jovi Dedaj.
If many of you have been following the news, you'll know that one of the dark clouds hanging over this year's presidential election, and future elections for that matter, is the controversy surrounding voter ID laws. One thing that I hope that this lecture convinces you about is that voter ID laws don't just threaten a fraction of the electorate, they're a concern for all of us. So the best place to begin is probably the lay of the land. Where are these voter ID laws? Which states have them? Which states don't? And how do they vary depending on which state you vote in? And I thought the best way to do this is to use myself as an example. Let's imagine for the purposes of this argument that I don't have a driver's license. For that matter, I don't have any form of government-issued photo identification. Instead, in my own wallet, I have 5 other forms of ID. I've got a medical insurance card, I've got 2 debit cards from 2 separate banks, a credit card, and my BC student ID, which ironically enough has my photo on it. Yet these 5 forms of ID, and any combination thereof, would not allow me to vote in 4 of the states on this map. And those are the dark colored states: Kansas, Indiana, Tennessee, and Georgia. Simply put, if I don't have a driver's license or other form of government ID, I can't cast a ballot. Obviously, it's not the same for every state. The other colored blue states like Idaho, South Dakota, New Hampshire, Louisiana, and Florida require that you provide some form of government photo identification, but it's not absolutely necessary in order for you to cast a ballot. For example, in New Hampshire, you can sign an affidavit that says, "I am who I am," and that allows you to cast a regular ballot. Or in the state of Florida, you can simply match your signature against the one that the Board of Elections has on record. And again, you can cast a regular ballot. I don't know if you can see it quite well, but the light blue states, which are more of them, they require at the bare minimum at least some form of documentary identification. In order for you to cast a ballot, you need to at least have something like a bank statement or a utility statement that has your name and address that corresponds to the one that they have on record. The vast majority of states, 18 of which, of course, have no identification requirements at all. You simply go to your local polling place, cite your name and address, they check you off the list, and you can cast the ballot. Of course, this map, even though it's only a month old, a lot has changed since. South Carolina, for example, which is a light blue state, recently had its voter ID law upheld by a district court in Washington, D.C. And now in South Carolina, you're required to provide government ID when you go to your polling place. This changing map, of course, puts this map into perspective. It comes from the Brennan Center of Justice at the New York University. Basically, in the last year alone, 41 states have enacted restrictive voter legislation law. Basically, this can mean anything from limiting the number of hours in the early voting period or requiring voters to provide government ID when they go to vote. But don't be fooled by the states that are colored in gray. As the previous map showed, Indiana, Louisiana, Arizona, and New Hampshire, which are in gray in this map, already have strict voter ID laws in place. They just haven't done anything in 2011 to make voting harder on the part of voters. Of course, other states are trying to do more restrictive voter ID laws, like Texas and South Carolina, but they've had a greater difficulty than, for example, Indiana or New Hampshire. This map, of course, is what I call the ID epidemic. The general trajectory of the 50 states in the United States is to make voting harder for citizens. So the first question is why, and why now? Why in the last 6 years are a number of states increasing voter ID laws and decreasing the number of acceptable forms of identification that let people vote? Rick Hasson, who in his book Voting Wars, he's a professor from UC Irvine Law, basically says that this is the reason why now. This is the 2000 county-by-county results of the presidential election between George W. Bush and Al Gore. And he basically argues in his book that Florida has been the primary impetus for strict voter ID laws in America, and the reasons are twofold. First, Florida proved to many people that we live in a very partisan era, and elections are extremely close. Even though Republicans carried the state and eventually won the presidency, it convinced Republicans and Democrats alike that elections are extremely close, and even for the office of the president, they can be determined by no more than a few hundred votes. So, as cynical as this may sound, it's in the interests of the parties, both Republican and Democrat, to tip the balance in their favor. And these restrictive, voter-suppressive laws do exactly that. But of course, Florida was also the battleground for what many people have seen, is a lack of confidence in America's elections. Florida was the election of the dimple Chad, the hanking Chad. Was it a vote for Bush? Was it a vote for Gore? And many people believe that the people's confidence in American elections, especially federal elections, is extremely low. So voter ID laws are essentially there to increase voter confidence and bring people out to the polls, even though they do the exact opposite. Some forms of voter identification fraud that happened in Florida and around the states were allegations that dead people were voting. Essentially, the state of Florida, along with some other states, had failed to purge their registration lists of deceased voters, and people were voting in their name. Another form was duplicate voting. Some people would fill out absentee ballots, send them in the mail, and still go to the polling place and vote. And another form, of course, although less frequent, is the fact that former felons who had lost their right to vote were still voting. Of course, none of these claims were actually proved, and many of them were unsubstantiated. Yet nevertheless, the proponents of voter ID laws believe that voter fraud is a problem, and these laws address that problem. But this graph would argue otherwise. This graph shows that since 2000, in spite of the thousands of elections conducted and the millions of ballots cast, little over 2,000 cases of election fraud have actually been brought forward. The graph doesn't tell you, of course, how many people were actually charged, moreover, how many people were actually found guilty. But this graph does tell us something interesting. Voter ID laws only treat a certain type of voter fraud, and that's in-person fraud. It doesn't treat absentee ballot fraud or other forms of voter fraud. It only treats voter impersonation fraud, and that only accounts for 0.5% of voter fraud since 2000. What can we say from this graph? Well, it's basically that voter ID laws are a disproportionate response to a problem that in many states doesn't exist, and in the ones that it does is statistically insignificant. So the question is, why do some states have them and why do some states not? But more importantly, why is it more difficult for some states to implement these laws while not for others? In 1965, the US Congress passed the Voting Rights Act, and it was signed by Lyndon Baines Johnson in August of that year. The Voting Rights Act of 1965 was and still is the most comprehensive civil rights legislation ever passed by Congress. Essentially, it wanted to end the widespread disenfranchisement of African American voters in the Jim Crow South, and it did that with resounding success. Section 2 of the Voting Rights Act basically rewords with stronger languages the protections guaranteed to every person in the 15th Amendment, that your right to vote cannot be denied based on your race. Section 5 is a bit more important and definitely more controversial, in that it states any voting change proposed by a covered jurisdiction must get that change approved first by the Department of Justice. And that's what the map on the right illustrates. 9 states in total are covered by Section 5, with a few counties and townships, most of which are located in North Carolina and Florida. Essentially, these states aren't allowed to propose any change in voting without getting the approval of the Attorney General. It can be something as minor as moving the polling place a quarter mile down the road, or something as big as getting an entire redrawn district map for congressional seats. Nonetheless, Section 5 was designed to prevent states from implementing measures that would disenfranchise minorities. And this explains why it's been more difficult for states like Texas and South Carolina to implement these laws. And while states like Indiana, which aren't covered by Section 5, have had a little more ease in implementing strict voter ID laws. So I thought I'd go over the preclearance process, as it's called. When a state comes forward with a change in voting method, like a voter ID law or a polling place, it has to provide the Attorney General with a reason for why they're doing so and the effect it'll have on minority voters. After his review, the Attorney General can issue a no objection. Essentially, the Attorney General has reviewed the submission and believes that indeed there is no effect on minority voting strength. The Attorney General can also object to the plan, at which point the proposed change is not implementable or enforceable. The Attorney General believes that minority voters will be disproportionately affected by the proposed law. With more complex cases like voter ID laws and redistricting, the Attorney General will often say more information is required. He can't make a decision based on the information the state has provided, so he needs more. Sometimes this is data turnout in elections in the past 10 years, but with voter ID laws, it's specifically the percentage of minorities that have the ID that the state requires in order for them to vote. Less frequently, of course, the Attorney General will say no determination. Basically, the Attorney General does not believe that the proposed change is either reviewable or, in fact, that the wrong submitting jurisdiction has made the submission to begin with. In the cases of objections, when a law has been shot down by the Attorney General, most of these jurisdictions can seek a declaratory judgment from a court in Washington, D.C. That's exactly what Texas and South Carolina did. However, since Indiana is not covered by Section 5, a private lawsuit was brought against the state, and it went so far as to reach the Supreme Court in the case Crawford versus Marion County Election Board. So it's appropriate to begin with Indiana because this was really the foundation for voter ID laws in the United States, and it set the tone for other states like Texas and South Carolina. The Indiana law was pretty straightforward. In order for you to cast a ballot, you needed to show ID, specifically a driver's license in the state of Indiana. The Supreme Court, in a 6-3 decision, upheld Indiana's voter ID law. The majority basically said you need to use a balancing test when you're judging the merits of voter ID laws. What you're balancing is the burden imposed on voters by forcing them to show ID when they vote, and the state's interest in preventing voter fraud, even if in a state like Indiana, there's no evidence for voter fraud. The very fact that the state wants to protect the integrity of its elections is enough in order for them to justify the burden on voters. Interestingly enough, Justices Scalia, Alito, and Thomas said that it's not even a burden that you're imposing on voters by requiring them to show ID. It's a mere inconvenience associated with voting that a person has to receive the requisite ID in order to cast a ballot. And so, on Tuesday's election in Indiana, if you don't have a driver's license or other form of acceptable government ID, you will not be able to vote. South Carolina was an interesting case in that initially it was denied preclearance by the Department of Justice. The Attorney General objected to the plan because, in his words, minority voters were disproportionately affected by requiring them to show ID when they went to the polls. However, when South Carolina took their case before a court in Washington, D.C., it was upheld. Like Indiana, South Carolina limited the number of acceptable forms of ID, most notably to driver's licenses. However, the courts found something in the law to be extremely important for justifying why it should be upheld, and that was the reasonable impediment provision. The law was written in such a way that if a person did not have the requisite form of state ID, he or she would be able to fill out an affidavit stating why they did not receive the requisite ID, and then, only then, be allowed to cast a regular ballot. The state basically said this would mitigate any of the effects on minority voters by essentially allowing them to vote only if they stated why they weren't able to receive the ID. Another important feature of South Carolina's law was the fact that they offered free photo identification cards to all voters. And that was a big thing for the court because it wanted to make sure that South Carolina's voter ID law wasn't a poll tax, preventing people from voting simply because they couldn't afford to receive a driver's license. But probably the most important part of South Carolina's law was that if you did not receive a free voter identification card, you could still use your old non-photo voter registration card. And this was a big deal for the court because essentially no one would be denied access to the ballot on Election Day in South Carolina. Texas, of course, was a big problem because unlike South Carolina and Indiana, Texas didn't consider any of these, what the court calls, ameliorative measures. When the Department of Justice and the court identifies an effect on minority voters, they look for how the law will correct that effect. As I mentioned before in the South Carolina case, the courts are looking to see whether or not these voter ID laws are just another form of poll taxes in disguise. Texas greatly reduced the number of acceptable IDs to your driver's license, a passport, and ironically enough, in Texas, the license to carry a weapon and a military ID. Of course, South Carolina, New Hampshire, and other states which have voter ID laws haven't restricted it to this few, but Texas did. And this was one of the many reasons why the law was denied preclearance by the Department of Justice and shot down by the court. Texas is a really big state. They have 254 counties, and 81 counties in Texas do not have Department of Motor Vehicle offices. So it's extremely difficult for people who don't have driver's licenses to go to a DMV office and apply for one. In fact, in some of the most extreme cases, it would cost someone over 250 miles round trip to go to the nearest DMV office and apply for a driver's license. Hours of operation was another big problem for the court. The fact of the matter is that most of these DMV offices do not have extended hours of operation. In fact, only 21 do. So most people would have to take the time out of their working schedule to go to the DMV office and get the required ID, which was a burden imposed on voters by the state, an unjustifiable burden. Probably most importantly was that Texas didn't offer any free forms of identification that would allow voters to cast a ballot. South Carolina did, New Hampshire did, but Texas didn't, and that was a reason for why the court shot it down. And of course, Texas didn't allow for any exceptions. If you didn't have an identification, there were no affidavits available for voters to sign saying, I am who I am, and I cast this ballot under threat of perjury. And there were no provisional ballots either in Texas. Provisional ballots would allow a voter to cast the ballot and then go back to the office of the Department of Motor Vehicles with the ID to prove that they were who they were and that the ballot ought to be counted. So, what does the future hold for voting rights and for voter ID laws? Harvard professor Alex Kasar, in his book, The Right to Vote, has said that the history of voting rights hasn't been particularly very linear, in the sense that the electorate has gone through periods of expansion and contraction. Women only got the right to vote when the 19th Amendment was passed in the last century, and the Voting Rights Act only passed less than 50 years. Clearly, the most fundamental right in our democracy is still the most contested one. Voter ID laws represent a trajectory on the part of states not to make voting easier on the part of the voter, unfortunately, more difficult. The one thing that I hope that you all get from this lecture tonight is the important constitutional right you all have, which is to vote. The presidential election is on Tuesday, and it's incredibly important that you all exercise one of the most constitutional rights you have. Whether it's casting an absentee ballot or going to a polling place in person, the voter ID laws confirm what many people to believe is the most precious right guaranteed to every citizen in a democratic society. Thank you.